Good afternoon, and welcome and thank you for joining us today on our webinar on 5 OCR changes to know before responding to your next complaint. My name is John Swinney. I'm an associate here at the firm, and I'm joined today by Jackie Werns, who's a partner here. For those of you who are not familiar with Franczek P.C, we are a law firm of approximately 40 attorneys who focus on labor and employment, education, benefits, and immigration. Before we get started, there are just a few housekeeping items to address. First, right under the presentation slides, you have the ability to type and submit questions. Please feel free to ask questions throughout the program by using this feature, and we will try to address them either as we go or save some time at the end to get to those. Additionally, everyone logged into today's program will receive an email that includes a link to the recording of the webinar as well as the presentation slides. Let's get started. So we have seen a lot of changes from OCR within the last year. This slide just kind of highlights a few of those. We saw the proposed regulations that were leaked in the New York Times back in September. We've seen the issuance of new guidance. We've seen the withdrawal of old guidance. We've seen internal communications about the scope of investigations. And we've also seen a resurgence of web accessibility complaints. Finally, we've also seen the OCR update its case processing manual, which will be the topic mostly of today's conversation. So on November 20th, 2018, OCR updated its case processing manual for the second time in 2018. The CPM, as OCR calls it, is the document that provides the procedures by which OCR investigates and resolves complaints against recipients or schools allegedly engaging in discriminatory or retaliatory practices. The CPM is not a law. It's not a statute. It's not a rule that has gone through any of the rulemaking process, so it's not a regulation. It didn't go through notice and comment. It's not even really the informal guidance that we've seen enacted and then rescinded and then enacted again under both the Obama and Trump administrations. But the CPM is kind of like the OCR Bible. It's pulled out and referred to at every stage of an OCR investigation, and there is very little that can be done if OCR interprets the CPM in a particular way with which a school does not agree. So it's very important for school districts and schools in general to understand what the CPM requires, what wiggle room and tools it provides to them, and what it should do if it believes that it's not being followed.
So as John mentioned, this was the second update to the CPM during 2018. And whenever I think about this, I can't help but singing the Rolling Stones, wondering if this is going to be the last time that we're going to see these changes to the CPM or see additional changes to the CPM. And this is particularly notable because prior to the March 2018 change to the CPM, we hadn't seen an update to it since February 2015. And before that, the last CPM revision was in 2010. So we really are seeing somewhat unprecedented changes to the OCR process, and particularly just the volume of changes we're seeing to the OCR process. And you would all be forgiven if you are having trouble keeping up. I will say that I recently rejoined Franczek after a 2.5-year stint at the Chicago office of OCR, and that even being within the agency while these changes have been going on, I was having a hard time keeping up. So really, considering all of these changes and the rescission of guidance, the issuance of all those informal directives that John mentioned, all the memos and the proposed rulemaking we've seen, it's kind of hard not to feel like OCR complaints are a bit of a black box, and particularly the process of how they're handled are within a bit of a black box. So what we were hoping to do today was to enlighten, shed a little light on these processes for you. And to do that, we're planning to discuss 5 major changes to OCR's process that will impact the defense of OCR complaints now. So these are 5 changes that we believe you should be aware of now if you're involved in responding to OCR complaints. We're not really going to be delving into what we think might happen in the future. Instead, we're focusing on what changes to the CPM are already in effect. So the issues we're addressing are changes to OCR's dismissal rules, changes to the rapid resolution process, a school's right of access to complaint information, the availability of resolution of agreements and changes to that process, and then changes to the procedures governing appeals. Before we jump into that, I did want to talk a little bit about OCR generally. OCR operates through 12 regional offices, including one in Chicago, where I was working for about 2.5 years, and which likely governs most of the people on this call. I will tell you this is not a full map. If you want to see the full map, you can go to OCR's website, but I had to fit it on our slide. So it does show most of the jurisdictions for OCR's offices. And one thing to keep in mind is that each office does things in different ways. So if for any reason you are outside of our jurisdiction, things may be a little bit different, but the vast majority of the things that we're talking about today will be applicable to people no matter where they are in the country. So let's talk a little about OCR's enforcement authority, and particularly the CPM. So the CPM really is what gives the procedures by which OCR investigates and resolves its complaints, and then also compliance reviews and directed investigations. For those who aren't aware, most cases that OCR investigates are going to arise from a complainant submitting a complaint to OCR where they say, the school that's in my community is doing something with which I don't agree. There is a process by which OCR can open up its own investigation based on its own initiative through a compliance review or a directed investigation. And the processes on those are a little bit different, but not entirely. But essentially, they start out in a different way. The CPM is broken up into a number of different sections. So I've got those listed here. It starts out with evaluation. Then it discusses a process called FRBP, which is the facilitated resolution between the parties. It used to be ECR, which was much easier to say, which was early complaint resolution, but the name changed under this administration, so now it's FRBP. The third section deals with case planning, investigation, and resolution. The fourth is what discusses those compliance reviews and directed investigations I just mentioned. The fifth deals with monitoring resolution agreements. The sixth deals with enforcement actions, which is where if a finding is made against a school and the school does not agree to voluntarily address the concerns through a resolution agreement, OCR would begin enforcement proceedings either through the Department of Justice and Congress or through the federal courts. And then finally, the last section is the appendices. So that's really that book, that Bible that John mentioned earlier. This is just the nuts and bolts of what you see there. Okay, so let's move on to our first topic of discussion for today. So starting out, we're going to be talking about dismissals. And before we do talk about dismissals specifically, I wanted to talk to you about the evaluation process, what that looks like at OCR. So OCR typically will receive a complaint from a complainant, and they will evaluate it to try to determine if it constitutes a complaint that's subject to further processing. When OCR does this, it's really looking for a couple of things. Number one, is the complaint timely? And number two, does it raise a concern of a violation of a law that OCR enforces? Those of you who've been involved with OCR complaints before know that OCR doesn't do an initial evaluation of the merits of a case to determine if it should be dismissed because there's not enough evidence to support it. Rather, this is just a look at the allegations themselves that the complainant has raised to make sure that the complaint is timely and that OCR has legal authority to investigate the complaint. Now, if the complaint isn't filed on time, OCR will give the complainant an opportunity to request a waiver. OCR's time frame is within 180 calendar days of the date of the alleged discrimination. So if the complaint wasn't filed on time, the OCR will go to the complainant to ask for the reason for the delay and for whether or not they want to request a waiver, which they pretty much always will say yes, that they do want to request one. OCR also has a process by which if it needs more information to clarify a complaint, it will contact the complainant and give the complainant 14 days to provide more information to help OCR determine if there's enough there for OCR to have the authority to open the complaint. So some of the reasons that OCR can dismiss a complaint are, again, if OCR doesn't have the legal authority, there's not a law. So like in some circumstances, you would see a complaint where someone comes in and says, I think I was discriminated against based on my religion. Well, that's not a law that OCR enforces unless, there's some tie to race. But in most cases, if they just say religion, that's going to be the end of the discussion for evaluation. Similarly, if the complaint fails to state a violation of one of the laws that OCR enforces, kind of the same idea there. Again, if the complaint wasn't timely and a waiver of timeliness wasn't granted by OCR, that can lead to a dismissal. And then there's some language that allows OCR to dismiss complaints if they are too speculative or if they don't have enough detail to help OCR understand that there has been a violation. That's one of those circumstances where OCR is going to go back and ask the complainant for more information. But if they respond and OCR still doesn't feel like it has enough there, they will dismiss the complaint. They'll dismiss a complaint if it's being investigated by another federal, state, or local civil rights agency or through a recipient's internal grievance procedures. There's a lot going on there, but essentially even if your institution has already looked at the same question, OCR is usually going to defer to that as opposed to doing their own investigation. And then similarly, if the complainant has already filed a similar complaint with a court, that's going to be an area where OCR is typically going to defer. Now, what happens if OCR does this evaluation? So we've got this process here. The complaint is filed, OCR evaluates it, and then OCR either dismisses it or it opens it for investigation. So if it dismisses it, you may never even find out about it, or at least under the old process, you may never have found out about it. A letter would go to the complainant saying, we don't have jurisdiction, or for whatever other reason, we can't open your complaint. Your complaint is dismissed. And maybe you might have received some oral communication from OCR about the case, but you're not going to get a letter to you directly saying that the case is dismissed under the prior process. If OCR opens the complaint for investigation, you do get a letter, and that's that one that says, we've received this complaint, we've decided that we need to investigate it, so please give us the following 67 bullet points of documents that is going to take you forever to respond to. So you all probably know that letter pretty well. So if it opens it for investigation, then you would get that letter. If it's a dismissal, you may not receive anything at all. And so some of you may be wondering, why do I care? Dismissals relate to the complainant. They don't impact me because in a lot of cases I don't even know about a case if it's dismissed. But as we're going to discuss in more detail at the end of the webinar, there have been changes to appeal rights under the most recent update to the CPM. And that means that complainants can now appeal certain types of dismissals. And recipients, also schools, have the right to respond to appeals now. And that means that you have to understand what the dismissal standards are in order to adequately respond to an appeal. It's likely going to be tough because you don't have access to dismissal letters, but since I have seen many, many dismissal letters on the inside in my life, I'm hoping to at least help get you started on the right path. All right, so what's the current state, and then what has changed with respect to dismissals? One thing that changed is that there used to be two separate sections of the CPM that allowed dismissal in both cases where there really wasn't enough detail to infer discrimination. It used to be under 108B and 108C. Under 108B, you would dismiss if you found insufficient detail to infer discrimination, and you would dismiss under C if something was so speculative, conclusory, or incoherent that you just didn't know what they were talking about. Now, these have been combined into one section, and I think that makes sense because most of these cases, you could use B or C. It could be a toss-up as to which one you would use to dismiss. But really, what we're looking here is something a little bit similar to where you might ask for clarification in a lawsuit, where we can't even really tell based on the information you've provided what it is that you're trying to suggest happened here. This is different than a failure to state a claim. A failure to state a claim is where we understand what it is that you're alleging, but it just doesn't state a claim of the law that we enforce. One that's a controversial but common one within OCR with failure to state a claim is with respect to discrimination on the basis of homosexual status alone, where there's no allegation that there's any discrimination based on failure to comply with gender norms. So that is a case where OCR has been interpreting its Title IX authority does not reach. That may change. That's been something that's up in the air. Obviously, things are treated differently under Title VII, but under OCR standards, that would be a place where you would see a dismissal. It's different, though, from 108B, where really the issue is that the complainant just hasn't given enough information. Maybe they are saying, I think I was discriminated against on the basis of sex, but the information and detail that they've given is too speculative for you to infer discrimination. Some other changes with respect to dismissals relate to whether you're unable to conclude that the allegation establishes a violation. So under the old CPM, there was this language about being unable to conclude that the allegation established a violation. The amendment in November changed this to cannot reasonably conclude that the recipient has violated a law. I think that this is lowering the standard. I think this is allowing dismissal in more cases. I'm not sure exactly what it looks like, but I do think that that change from unable to cannot reasonably means that you're not going to have to meet some insurmountable standard of showing that that the information provided isn't sufficient to establish this. With respect to 108, what used to be 108U and what is now 108R, there used to be a dismissal provision that allowed for dismissal if the matter was moot, meaning that it no longer was a valid ongoing concern. So this happens a lot in OCR cases where the student has graduated. People will say, it doesn't matter anymore what happens with them in this class because they aren't here anymore. That's moot. There was an addition of this language about ripeness, though, to the dismissals. And so what this means is that the case has not yet come to a point where there's a violation. So we could potentially see this coming up in cases where someone says a policy or a rule that's in effect is discriminatory, but it hasn't yet actually been applied to that student, we might have a basis now under an OCR complaint to argue that that isn't ripe. Now, one last set of changes that we've seen with dismissals, and then I'll kind of talk a little bit about why, again, all this matters. But the last one that we've seen that's really notable relates to the filing of complaints elsewhere. So it used to be that under the 2015 version of the CPM that you would dismiss a complaint where the complainant filed a complaint with the same allegations with a court or with another administrative body or within the school's own system. In that realm where it was the complainant filing the complaint, you were mandated at OCR, will dismiss. If the complaint was filed by a third party with a court or another agency or with your internal process, you could, as OCR, dismiss the complaint. And then once that complaint in the other body was finished, you would be able to come back to OCR, and OCR would do a limited review just to make sure that the evaluation in the other body wasn't completely screwed up. In March 2018, there was this language added to the CPM where any complaint, no matter who it was filed by, would be dismissed if the complaint that was filed in the other body had the same or similar allegations. So it didn't have to be the same anymore. It's the same and similar allegations based on the same operative facts, and the allegations could have been raised in another court. And I will tell you that this was internally very confusing as far as what this meant. There's a lot of discretion that this gives to OCR staff members as far as what it means that something could have been raised in another court. And I think for that reason, the language was removed in November. So now that could have been raised language was removed, and we're in a place where we're still looking at same or similar allegation based on the same operative facts. But it has to have actually been filed. The allegation at issue has to have at least been filed, or something similar to it has to have been filed in the court. It's no longer enough for it just to could have been raised. So as for why this matters, we're going to again talk about this quite a bit when we get to the appeals section. But really, it's just now become really important for you to at least understand that these dismissal provisions exist because, number one, you're going to need to either challenge or support OCR's decision on an appeal, depending which way they went on these issues. But also, I would argue that if you get an appeal and you think that there could have been a dismissal based on another basis, another dismissal prong, I think you would want to raise it at the appeal, even if OCR hadn't already discussed it. Because this is giving you an opportunity to step in and say, I think that this should be dismissed for this reason. Another thing to keep in mind is that even putting aside this appeal issue, you've always had the right to argue that cases should be dismissed even after you've received a letter of notification. So again, you're going to want to look at the language in the CPM on this and make sure that you at least are aware of what facts you should look at before you allow OCR to complete its investigation. Is there some basis for us to dismiss this complaint?
So the next big change to know about is a change to the CPM section on RRP, which is the rapid resolution process. Since the beginning of the Trump administration, OCR has been expanding its use of rapid resolution process, or RRP, which allows OCR to negotiate directly with a responding school to effectuate compliance without a full investigation. Under the previous version of the CPM, RRP could only be used for certain types of cases and only at certain stages of the investigatory process, Now, we'll get into how that's changed in just a minute, but I think before we do that, it's important to have a little bit of background information about RRP and how it works. So the rapid resolution process is an expedited case processing approach that can be used to resolve cases in any of OCR's statutory areas, either during the investigation evaluation stage or after issuance of the letter of notification. The outcomes in all RRP cases must meet OCR standards for legal sufficiency, and they must be consistent with the applicable statutory and regulatory authority. Any resolution agreement reached through RRP must be aligned with the allegations within the complaint itself deemed appropriate for resolution pursuant to RRP. So there are a few ways that RRP can work, and they're outlined here. You'll see section 110A, 110B, and 110C. And RRP can be used to resolve the complaints in those three different ways. So first, under section 110A, that's where a school has already taken action to resolve the specific complaint. And in that instance, the school can request a dismissal. And that's important. We'll come back to that in a little bit, but I want to run through all three first. Under section 110B, the school can promise to take action, or the school could have already taken an action that OCR determines needs continued monitoring. In that case, there will be a letter of finding and an agreement. And section 110C is where OCR finds that sufficient information exists from the recipient to make a determination right away without having to go into an investigation. Like I said, what's important to note here are the different possible outcomes, because that's what's going to make a difference. A dismissal under 110A is the gold standard. You want a dismissal if you can get it. Because when you get a dismissal, the case ends with no investigation, no resolution agreement, no monitoring, no finding of fact. The case is just done. OCR says, okay, you've taken care of the problem. This is moot. We don't need to write anything up, and we don't need to look into this further. Now, under 110B, it's still a good approach. 110B is a good outcome because they're going to wrap up the case quickly. But under 110B, you're going to have a finding of fact. You're going to have a summary of the investigation, findings, what the school did wrong, and there might be monitoring in the future to make sure that you comply with the agreement. Like I said, this is still a good outcome. It can save time, it can save money, and it can save the risk that OCR finds something else while they're investigating. But it's not quite as good as 110A.
So just to give some examples from kind of the real world about what these might look like, these different situations. So section 110A, where it's an action that's already taken to resolve the complaint. An example there of a case that I dealt with was where a school, it was a higher education entity, and they had an automatic email that would go out to students when they hit a certain number of days of absence. And we received a complaint saying that this violated Section 504 and Title II of the ADA because this student in particular who received one of these notices, he had accommodations that allowed him, based on his disability, to have a certain number of absences and to be allowed to make up work. So you can imagine two outcomes here. When I called the school and said, you know, hey, is this really happening? This seems pretty easy to fix. Do you want to consider doing this through RRP? The first option is for the school to just say, yeah, okay, we're going to change it, and send me a copy of, you know, for instance, maybe they just put a line in that email that says, a disclaimer that if you have accommodations based on a disability, this may not apply to you, and please contact the Disability Services Office. If they sent me a copy of that email as the investigator, that would probably be enough to settle things. And we wouldn't have to monitor. There would just be a dismissal letter sent to the complainant that says, you know, we understand this has been fixed and we don't have jurisdiction anymore. End of case. The school also could say, you know what, we do want to fix this, but our process is kind of slow. It's going to take some time for us to do this. So we don't want you to do an investigation. That would be a waste of time, but we can't fix this right now. So in that case, as the investigator, I would be looking at 110B, which is where I would say, okay, we're not going to proceed with this case. I'm going to issue, I'm going to get you to sign a 302 agreement, which is an agreement where we are going to end things before the investigation completes. And I'm going to issue a pretty short letter that just says some basic facts and says the fact that you wanted to resolve and that we're going to resolve it. So the benefit there is that, there's still not going to be an investigation. The complainant's out of the picture. We now just have an agreement with just the school and OCR. So that can be a positive thing, as John mentioned. I will say with respect to 110C, that's not necessarily a good thing for a school. If they already have sufficient information to make a finding of noncompliance against you, they can do it. I never saw this happen. Usually OCR will at least conduct a basic investigation. And that makes sense because the school does deserve some process and some right to defend themselves. But that's why we're not talking about 110C. It's not really something that's going to come into play, nor would you necessarily want it to come into play.
Well, and Jackie, I would imagine too, as an OCR investigator, they must love 110A and 110B, right?
Absolutely. I mean, this was always the first place that I would go when I would be assigned a complaint and I would realize that it couldn't be closed as a dismissal through the evaluation stage without any action by the district. If it was something simple, I was going to try it because, this means my case goes away and I don't have to conduct the investigation. But John's going to talk about this. In the old days when I was there, I had to be the one to initiate the RRP process. And so that meant, you had to rely on being assigned an investigator who saw the value of this. And I would say in my office, everyone didn't necessarily go to this as often as I did.
And that leads perfectly into our next slide here, which is, so what has changed now with this process? And what this slide shows is the actual edited text of the changes that were made in the most recent CPM amendment. Now, in order to understand these changes and to explain a little bit of what Jackie was just touching on, the OCR process is laid out very specifically. First, OCR gets a complaint. They then talk to the complainant and review the documentations that are provided. They next determine if they have jurisdiction to open the complaint for investigation. And only at that point, after they've decided whether they're going to open it for investigation, do they notify the school. And they do that through issuing a letter of notification, which is referred to in the highlighted section here. Now, it used to be, as you can see, that the language in the CPM stated that an RRP was only allowed prior to issuing a letter of notification. So as Jackie said, she used to reach out to these schools and ask them if they were interested. These schools at that point might not have even known that there was anything open against them.
Yeah, that's right. I mean, really the only way that they would know is if the complainant had been the one to notify them, which sometimes they do say, hey, I filed an OCR complaint, but they hadn't received any notice from us.
Right. So under the old language, once you got that letter of notification, once you were on notice, it was already too late to try to resolve this through RRP. So that changed. Now that language has been removed, and as you can see, the language now states that RRP may be attempted either during the investigation or after the issuance of the letter of notification. And this is good for schools because it puts schools on notice of the allegations that are against them. It allows them to attempt to resolve this matter and possibly get it dismissed before any investigation even occurs. So the key takeaways: if you currently have an OCR complaint that is open and in investigation, but it might be possible to resolve it through RRP, you should approach your OCR attorney to discuss RRP as an option. You should look at the three options that we highlighted before, although really two of them are really what are available to you. And if you have a choice, you want to go with the 110A dismissal. You want to rectify the situation and get the case dismissed. Now, we have a couple of examples for you too. In this first one, student A requested extra time on a semester exam. based on a disability. Student made the request to the teacher directly, but the teacher denied the request without directing her to speak to the disability services professionals. Student filed an OCR complaint, and we know that had the request been directed to the proper location, it likely would have been granted. So what do? Well, we know that the school does not have a problem with this accommodation. If the student had asked the correct person, if this request had been directed to the right channels, the student would have been granted the accommodation. So why fight it? Call OCR, let them know we received this notification, this is what I understand the accommodation that was denied is. We're happy to grant that. And in fact, we are or already have granted it, and we expect that this will lead to dismissal under 110A.
So looking at this example, John, it making clear, it seems like you really have to have a sense of what the complaint is and have a pretty specific sense of it in order to use this process.
That's exactly right, because you have to be able to rectify the exact issue that was alleged. So you have to really have a specific concrete grievance that you're able to fully correct.
And as we all know, you look at that letter of notification, and in most cases, it alone is not enough to really let you know the specifics. They're usually pretty vague. Sometimes if you dig in and look at the documents that are requested in the letter, it'll tip you off on what some of the specific concerns are, but usually it's pretty limited. So this almost always is going to require you to either have knowledge from your interactions with the complainant about what their concern is, or you can always call the OCR investigator and ask them for more information. In my experience, people tend to, if they ask for information about the complaint at all, which you would be surprised at how many people don't, but many people will just submit a FOIA request, which takes 20 days and usually is going to end up with you getting a redacted piece of paper that is completely illegible. So pick up the phone, call your OCR investigator, develop relationships with the investigators who handle cases for your school, and ask them, all right, listen, what are the facts here? Because maybe we could do something about this and save everyone a lot of time.
Right. So in this second example, you receive a complaint from a female student that the boys' basketball team is being given preference in the use of a nicer gym at the school for practices. And that's a valid complaint under Title IX. You get a letter of notification from OCR that they've opened this matter for investigation, and you do your own research, you speak with your staff, and you determine that there is a problem, that this has been occurring. So what should you do? Again, contact OCR and let them know that this practice is done. You want to make sure that it's clear to the OCR investigator that the practice has already been remedied, that you've already taken steps to make sure that this doesn't occur. You don't want to just promise that at some point in the future you'll take care of this, because that might lead to a 110B. And again, not that that's a bad finding, but it involves monitoring sometimes. And it can involve finding of facts that are not good to the school. So you want to get it dismissed. You can send OCR documentation of emails to the coaches explaining why this practice needs to stop and what the new policy is, emails to teams, or even a new written school policy, which would demonstrate that you've already addressed this issue. You could even have an informal training of the decision maker, so here the athletic director. And I say training with a lowercase t. It really could be as simple as them meeting with their supervisor to go over why the last practice was not sufficient and what the new policy is.
And this is one of those areas where there are many times in the OCR process where negotiation by or on behalf of the school is so important, because this is one of those places where you could really see this either way. You could see this as a 110A where you get a dismissal letter, or a 110B where there's monitoring. And I would say that as a person who represents schools in these matters, I never want to have OCR monitoring if I can avoid it, because I've had cases where it's gone on for years. So if you can avoid it, this is where negotiation and really arguing your case to OCR about how they should interpret this is so vitally important. So let's switch gears and talk about complaint access. So I mentioned this a little bit before. Historically, the only access to the complaint that you could get would be through FOIA. As I mentioned, the letter of notification is usually pretty vague. It doesn't include the name of, it doesn't include a copy of the complaint. It does now at least include the name of the complainant, which is something that has changed recently and is nice. We used to have to call and ask for the name of the complainant, but that's at least in that letter. But we don't get a copy of the complaint. And historically, under the versions of the CPM prior to 2018, the only way you could get access was to submit a FOIA request to OCR and ask for a copy of the complaint. So you could send an email to your attorney or investigator and say, I want a copy, and they would process that as a FOIA request. Now, for those of you that are Illinois public bodies, you know that under the Illinois FOIA, there's a pretty rapid response time. It's, at most 10 days. That is not the case under the federal FOIA. The federal FOIA gives 20 days, business days, to respond. As a former member of the OCR FOIA team here in Chicago, I can tell you that that can drag on, particularly around the holidays. So it could be quite some time before you get a copy of your complaint. And then when you get it, as I mentioned before, it's usually unintelligible. It's heavily redacted. Almost everything you need isn't there. So in March 2018, schools everywhere rejoiced because the CPM was revised to state that a copy of the complaint will be provided to the recipient if requested. And everyone rejoiced because why would they add to the CPM that you had to give a copy of the complaint to the recipient if they requested it? If you could already do that under FOIA, that would be completely unnecessary. However, OCR still interpreted that change to only allow a school to get a copy of the complaint through FOIA. It did attach this random shorter timeline in some cases to it, but it was almost just like a, we'll try to get it to you in 10 days if we can, but if we can't, we still technically have 20 business days under the FOIA. So it was really quite a strange response, I felt, at the time. Then in November 2018, the CPM was revised again. So now it removed if requested, and all it says is a copy of the complaint will be provided to the recipient, period. Now again, logically speaking, I would interpret that change to mean that every time there is a complaint and every time there is a letter of notification, that OCR is going to attach a copy of the complaint and send it to you. And I would interpret it again to be unredacted because this apparently is a process outside of FOIA. Unfortunately, that is not how OCR has been interpreting this since the change in November. They are still requiring it to be handled under FOIA, and they appear to still be requiring you to make a request for the document. So the real takeaway here is that if you receive a notice of a complaint being opened, a notification letter from OCR saying that a complaint has been opened, the very first thing you should do on the very first day that you learn of it is to send an email to your OCR investigator and request a copy of the complaint. And I would frankly explicitly state that you want an unredacted copy because this isn't a request pursuant to FOIA. This is a request pursuant to the case processing manual. I don't think that'll get you anywhere, but frankly, if enough schools keep pointing this out, at some point it will at least become difficult for OCR to continue ignoring it.
That brings us to changes in the resolution agreement process. So as a bit of background, resolution agreements occur when OCR gets a complaint, opens the complaint for investigation. The complaint does not end through the RRP process, which I previously described, or through FRCP, which Jackie touched on earlier. That's the facilitated resolution between the parties. And the investigation has begun. And there are two types of resolutions that can occur. Both of them are on your screen, Section 302 and Section 303. Under a Section 302 resolution, A complaint may be resolved before the conclusion of an investigation if the recipient, the school, expresses an interest in resolving the complaint and OCR determines that it is appropriate to resolve the complaint because OCR's investigation has identified issues that can be addressed through a resolution agreement. The provisions of the resolution agreement must be tied to the allegations and the evidence obtained during the investigation and will be consistent with the applicable regulations. After the recipient signs this resolution agreement, OCR will issue a resolution letter, which will describe the investigation, the findings up to that point, where the resolution was reached. Under Section 303, this occurs after the investigation has finished. This occurs if OCR determines that a recipient did fail to comply with a civil rights law that OCR enforces. In this case, OCR contacts the recipient, the school, and will attempt to secure the recipient's willingness to negotiate a voluntary resolution agreement. If the school agrees to resolve the complaint, the school will negotiate and sign a written resolution agreement that describes the remedial actions that the school has to undertake. OCR will monitor the school's implementation of the terms and the obligations of the resolution agreement. Now, if the recipient does not agree to correct its noncompliance with civil rights laws, OCR may initiate enforcement proceedings, but this never happens. 99.99% of the time, a school is going to agree to negotiate the resolution agreement. So what's changed? One major question of change deals with the Section 302 resolution agreements. Those are the ones that are an agreement before the investigation has concluded. And it looks like a pretty minor change on your screen. It's the striking out of with and then the addition of because OCR's investigation has identified issues that can be addressed through a resolution agreement. But OCR has long interpreted the language of this section, the old language of this section, to allow them to reject an offer of a 302 agreement if the school makes one, if there have been issues found in an investigation that would warrant a finding of noncompliance. So if they've found something in the course of their investigation that they believe is a violation, they've long denied any kind of resolution agreement based on that evidence. And this language may take away some of that discretion. We don't know. We'll have to see how this plays out. But it does seem here like the new language is stating that, you know, if there's a problem, you should still be able to resolve it through resolution, and that just makes sense.
Right. I mean, the biggest thing for me is that, I mean, really, so OCR shouldn't be requiring a school to enter into a 302 resolution agreement if there's not some evidence that they engaged in some wrongdoing. I mean, it's almost like, you know, you hear about the concerns with people accepting plea bargains just to avoid the risk of going to trial. And this is kind of, you know, the same thing that, you know, OCR long sort of took this view that you could only have a 302 agreement if, you know, you hadn't found anything or identified any issues. This at least raises the question of whether or not that has changed, and that now even if you have found something wrong, you can still enter into an agreement under 302 as long as you haven't fully completed your investigation.
Right, and we'll have to see how that language actually plays out in practice. Another seemingly minor change, bullet point 2 here, states that 302 resolution agreements must now specifically be tied to the allegations and the evidence obtained during the investigation. So with regard to SOC, which stands for Statement of the Case, that's a document that OCR staff have to complete during their investigation. And now, basically, the Statement of the Case must identify specific concerns that support the need for the specific agreement provisions. And now, you're not going to see the SOC, but when you're faced with a resolution agreement, you can now ask the attorney, the OCR attorney, or the investigator on your case, what the specific concerns are that they have identified through their investigation or that were alleged that necessitate the terms of the agreement. So what does this change look like? Let's say that OCR tells you to revise your school's policies. There were no allegations about policies in the initial complaint, and from what you can tell, no investigation showing policy was a concern. Under this new language, schools can negotiate and should negotiate to not have the policy revision requirement in the agreement. Schools can point to this language in the CPM and ask the OCR to affirmatively establish what the basis is for that recommendation.
And I would say, too, that, with a lot of these things that we've been talking about today, with a lot of these changes, including this one, I hope that many schools had already been making these arguments before. I hope that schools have already been saying during the resolution agreement negotiation process, hey, why is this included? This doesn't seem to have anything to do with our case. But this is just a valuable place to point to say, I think you've got to do this. I think you need to tell me, OCR investigator or attorney, why you're including this. And the same thing with the denial of a 302 agreement if they found something that supports a violation. Obviously before, I would argue, and I had many attorneys argue to me that, come on, let's just resolve this thing. But now they have something specific that they can point to say, you know what, this is directing you, OCR, that you need to do this. So it's just a little bit more evidence in your pocket in order to make these claims.
Exactly. And on the final point here, with respect to the final bullet, before the Obama administration, when you entered into a 302 agreement, which again is before the conclusion of the investigation, the letter issued was short and sweet. It didn't include any information about the investigation, any facts found, or any of that. During the Obama administration, that changed, and that was a big deal for schools. Because even if they agreed to resolve during the investigation, OCR could still publish negative information about the school through its summary of the investigation. I think we sort of expected to see that language be removed or at least lessened. But actually, the new CPM language kind of doubles down on that and requires inclusion of the evidence obtained prior to the 302 resolution.
So our last topic, as I alluded to when we were talking about dismissals, is appeals. And really, this has been another place where we've seen kind of back and forth, flip-flopping, if you will, in the CPM about how this all is handled. In the 2015 version of the CPM, and really the versions before that, there was an appeal process. It only applied to findings of insufficient evidence, so where a complainant had filed a complaint and OCR had done an investigation, and in the end they had said, you know what, there's not sufficient evidence to support a violation of a law that we enforce. And in those cases, the complainant could appeal based on incomplete facts, incorrect analysis, or an inappropriate legal standard applied by the OCR team. This process was frankly quite onerous on OCR staff. It really was. It's a thorough process of appeal. It's within the office. There's a person who's identified as being sort of in charge of appeals, and then the director, the regional director, which in Chicago is Adele Rapport, would be the one to make the final decision about the appeal. But it was it was an onerous process. It required the team to justify internally why it had reached the decision it had reached. And in March 2018, the revision to the CPM completely deleted, completely removed the right to an appeal. And as I'm sure you all heard and could have imagined, people reacted to that pretty strongly on the complainant side, saying, there needs to be some type of review. So now, as of November, those appeals of insufficient evidence, 303A, those are back. And in fact, the administration has given complainants more rights to appeal. So they've identified specific examples of dismissals where a complainant can now appeal. And another thing that was changed was that the recipient or the school will receive a copy of the appeal and can respond within 14 calendar days. This is really important. As I noted before, you should obviously raise any issue that you think justifies dismissal or a finding of insufficient evidence, even if it wasn't address by OCR in their dismissal letter or in their letter of finding, you should address those things. Another thing to keep in mind is that I'm sure some of you have run into the situation where you receive your complaint notification letter and you look at the date on the letter and it lists the date that was 7 days ago, and then the letter says you have 15 days to respond from the date of this letter. And so what do we all do? What you should be doing, if you're not, is calling your OCR investigator and saying, I just received this. I need extra time. Can you give me an extra 2 weeks? And they almost in every case will agree. So you should be doing that. Well, here I actually just got one of these appeal letters today, and it says you can respond within 14 calendar days, and it's of the date of this letter. And I'm very curious to see if there will be any flexibility on that date, because you know, I'm positive we will be able to respond in this particular instance within the time period we have, but there could be circumstances where you would want some additional time to respond to an appeal. So it's at least worth asking to try to see if there's any additional time that will be granted, but I'm not sure because they have a time frame by which they have to make a decision on these appeals. So you may not be able to get any extension. So definitely very important to pay attention to the date that that letter is received and to advocate as much as you can for your school's position. This is a good move for schools, I think, in the sense that it gives us one more opportunity to ensure that things go our way in these cases. Well, that is all. We have 3 minutes left, but I don't see that we have any questions. So I think we're just going to let you guys off a little bit early. There is a copy, there will be a copy of the PowerPoint available.
Correct. The recording and the PowerPoint slides will be emailed out at the end of this.
Right, exactly. And then typically also, please note that our webinars are usually available to listen to or watch again on the website. So if anyone in your school didn't get a chance to participate today, please go back and check out both this webinar and other past webinars that we have available for you that are on our website. If there are ever any topics that you would like us to cover on a webinar, please reach out to one of us and let us know. We're always interested in trying to find ways to help you deal with all of the issues that you're facing out there so that you can focus on, educating students. So thank you so much for joining John and me today, and have a great day.